The launch of the Article 14 Sedition database, the most comprehensive repository of data around the 151-year-old law of sedition, under which you can be accused of causing disaffection against the state. It is broad, it is vague, and it is used in a manner it isn't supposed to be. And when deployed with other laws, can ensure that people are locked up essentially for no logical, legal, or justifiable, or perhaps justiciable reason. Let me start off immediately by introducing you to our speakers today, beginning with Rebecca John, of whom I am but one of a legion of fans. One of the most significant things about her is that she fights most of her legal battles in the trenches, the trial courts, where, as our sedition database indeed indicates, the most significant travesties of justice occur. I will not spend time on many accomplishments and cases, but I will just say that she has consistently appeared for the underdog, the underprivileged, and those are most in need of legal representation, so to say. Aakar Patel is most famous online these days for his daily dose of garbled tweets commenting slyly on India's turn to autocracy, and also the accompanying photographs that showcase his collection of dolls from Gandhi to Modi. You can log on to his Twitter feed and see what I'm talking about. So we tend to forget that he's actually a serious man with a serious body of work. He's the chair of Amnesty International India, the author of two deeply researched books on New India, the translator of Manto, and a popular target for the heavy hand of the state, irreverently answering, as he does, a series of summons from the police and the enforcement directorate. Varun Grover is a national award winning song and script writer, stand up comic, and poet who wrote the famous Hum Kagaz Nahi Dikhayenge poem that became the unofficial slogan of the anti CAA protests. For me, his greatest attribute, and I think at a time when being funny and political at the same time is a fraught endeavor, is that he does not hesitate to take on people and systems more powerful than him. He's also one of those rare engineers with a sense of humor. In a country where reality is often indistinguishable from satire and black humor, as many cases in our sedition database reveal, Varun was once asked, "What's the impact you're hoping for?" He replied, "First thing we hope is that nobody kills us. Second, that people have a good time and engage with our ideas." So that's what we hope to do today, engage with ideas and data. And to do that, let me begin first with Lubhyathi Rangarajan, editor of our databases and the driving force behind the sedition database. She is a lawyer, the co-author of a highly regarded research on the death penalty, very well organized and planned in her work. So it's quite something that she survived a year of working with journalists and other, chaotic type of personalities who she suffered in pulling together this body of work. So we'll start off straight away with Lubhyathi. Go ahead, tell us what it was like to pull this together and what did you find?
Thanks, Samar, and thanks to our panelists and thanks to everyone for tuning in for what should be a really interesting conversation and of which I might just be a very small part. I think, just to begin, this work, I think first, something that we learned when we went into this was that it just shattered a lot of our assumptions we had. And we went in with certain empirical and qualitative assumptions about sedition or the prototype of who is considered seditious in this country. And that prototype is often somebody who is outspoken, who's critical, who's a protester, who's a dissenter, who's a politician, who's active on social media. And so much of what we discovered was that people who are being arrested for sedition very often are none of these things. They do not fall into any kind of category. And that assumption or that sort of shattered assumption is represented in our data in this category called everyday. And this is something that was extremely startling to us. We didn't expect it. And so if you actually visit our website, you will see a whole range of cases filed against ordinary people living ordinary lives and doing ordinary things like wearing a t-shirt or dancing to a song. And even in one case where somebody had a loud motorbike silencer and someone was offended by it. And that sort of spiraled into something which then led to a sedition case being filed. And I think these kinds of assumptions we did not have when we went in. And so that prototype of who is considered seditious today has certainly shattered, and you will see this represented in our work. The other thing, of course, is that this idea that there is always a national context that plays out in sedition, and this is also not true. I mean, so much of what we saw was hyper-local politics. For example, who file sedition cases. This is again an element of sedition that is often missing. The focus is often on the accused. And the focus on the accused is also fueled by a certain public imagination or mainstream media reporting of a sedition case, of certain sedition cases that tend to dominate headlines. And there are a lot of these everyday cases that sort of get missed out in that. And part of that backstory of the everyday cases is also complainants in sedition cases. And what we found particularly in Karnataka through our reporter was, in fact, in one case where the complainant and the accused were actually sitting together while he was interviewing them. And he had no idea what to make of that information. And when he sort of relayed that to us, even we didn't know what to do in such a case, because it's so odd that the complainant and the accused actually know each other. In another case, the complainant actually regretted filing a sedition case and regretted having done that to somebody they knew in that village. So much of what we discovered about sedition is not high profile. It's not reported in mainstream media. It is completely sort of flying under the radar. And it's only through, not just through, the kind of manual data mining that we may have done and that we did, but it's also through actually going to the field and talking to people who are accused of sedition and talking to their families and sort of digging deep into that we discovered what the story of sedition really is. In another case, in Karnataka, and this again shattered our assumptions about what we might know of documents. And when you're sort of evaluating documents as researchers, we came across 6 bail orders in Karnataka, all of which were basically copy pasted. The only thing that changed was the names of the parties, and this was, these were 6 trial court orders. And so on just reading all 6 orders, you might think these are all men who were part of perhaps a WhatsApp group. They were all arrested for posting something on social media around the time of the Pulwama attacks. And on reading all 6 bail orders, which were completely identical in content, you might think these are all men who knew each other, who were part of the same WhatsApp group, who were part of some sort of gang of some sort. And again, it's only when our reporter went, tracked them down and spoke to them is when he realized that they didn't know each other at all. They all met in prison for the first time. This was all an algorithmic sort of mystery. They all happened to click on the same message on the same day at the same time, and were unfortunately then charged with sedition. And so these kinds of cases, and there are so many more of them that we discovered in our work, it only tells us that we can't be certain anymore of what we think we know about the seditious republic. And the only way we can discover more is by actually combining this kind of data mining or documentary sort of analysis with also going to the field. The other sort of overwhelming sort of sedition case you see are social media users. Again, you might think these are outspoken critics or outspoken politicians or someone who's protesting something, and it is not. Again, around certain specific events, and this is something that we discovered while researching, which is the date of the event. And so very often we were able to trace cases just based on a certain date. And when you sort of do some intuitive or intelligent guesswork around that date, you find out what the political climate was around that time, and then you find out why that person was actually arrested. And we saw this play out, for example, in the Pulwama time. We saw this play out in a case, in fact, that was around Muharram. And so the people who were wearing T-shirts were arrested around the time of a Muharram procession. And so a lot of this is also possible because we tracked the dates of when cases are actually filed, which is also another important piece of the sedition puzzle, that there are certain political events that play out either nationally. They may even be religious festivals. They may be bills that are passed in parliament. And that translates to a very local level. For example, something like sedition cases filed against people protesting the NEET exam in Tamil Nadu. This is not something you see play out in any other part of the country. And so, what happens in Karnataka in terms of sedition is not the same as what happens in Tamil Nadu, and it's not the same as what happens in Jharkhand. And again, so that idea that there is always a national level context and there is always a national narrative that is propelling the increasing number of sedition cases being filed is also something that we had to unlearn in our work. And in one particular case, for example, again, speaking of the police and how quickly they file sedition cases. In one case, it was a waiter in Mysore who was actually from Tripura, and the police sent a team from Tripura to arrest him in Mysore because of what he posted on social media. And so when you think about that kind of investment in catching somebody who posts on social media, someone who is perhaps a daily wage laborer, and that's the kind of investment that, you know, the executive machinery is putting into no longer just the active dissenter, the active protester, and the active politician. And so these are all some of the things we learned, you know, through our work. The other sort of, and you know, you will see this play out in how we've represented the data, is also that it is therefore not singular. There is a range, there are a range of variables and correlations that can overwhelm you, that is confusing, and that is disruptive. And all of that is intentional, because we're trying to say that this is not simply a story about X number of cases being filed against a certain kind of person in a certain year. This is much more than that, because your fate can actually hinge on whether you are a Muslim journalist in UP or whether you are a Hindu professor in West Bengal, and whether therefore you can afford to say file for anticipatory bail and get it from the Supreme Court, or whether you can't even afford a lawyer, and therefore you have to spend at least 3 months in prison because you happen to click something on social media. And so here we also get into the territory of the courtroom and how sedition plays out in the courtroom. And of course, we need to do more research around that, because courts are neutral spaces and courts operate under very different judicial considerations. And here it will be Kedarnath Singh, the judgment that upheld constitutionality of sedition. And the standard, of course, is incitement to violence. But the kinds of cases that you see filed here defy all logic, and then you're left wondering, what is the meaning of Kedarnath Singh really? And you know, why is it that that judgment should be applicable only at the time of trial? Why is it not applicable at the time the FIR is filed? And so all of these, and the courts therefore in dealing with sedition might do so from very sort of neutral territory, and you know, applying an objective analysis to all of this. But it was certainly not our endeavor to be neutral about what we're seeing. It was our endeavor to present every possible correlation that can determine your fate if you happen to be accused of sedition. And so much of that was also intuitive or intelligent sort of guesswork we had to do. The more and more we discovered this, and therefore you see, for example, you know, occupation of the complainant, occupation of the accused, their age, religion, gender, you know, the state they're from, the chief minister of that state, and so many of these factors that ultimately will decide whether a case is filed against you or not. And I think, to me, certainly what all of this has ultimately represented is that there are some extremely deep and very jagged social, economic, and political fault lines that have you know, that run through this republic and have run through this republic for decades. And I think, you know, what we're seeing really is a very small snapshot of that. You know, we've managed to dig just a little deep to understand what the backstory of sedition in this republic really is. And there is no single story. It is not a singular narrative. It may not even be a national narrative. And today it is certainly a very, very hyperlocal narrative.
Okay, great. Thank you for that introduction. And as we get into those particular narratives, let me just get first into Varun. Laws like sedition and others that are used in conjunction with it, and we'll get Rebecca to talk about this, have had a strong chilling effect on the performing arts. How do you express your creativity and make the kind of comment you like to make at a time like this, when you know that sedition is only a joke away, or sometimes not even that?
Yeah, so sometimes not even that is you know, is a way to go about it, or to think about it, कि जब कुछ भी नहीं करके भी sedition लग सकता है, तो फिर हम चुप क्यों रहें? जो हमको बोलना है हम बोलेंगे. क्योंकि अगर जैसा कि जो एग्जाम्पल्स मैंने देखे कुछ जो आपकी रिपोर्ट में हैं, some of them, there is a guy जो अपनी मोटर बाइक में साइलेंसर के बिना घूम रहा था, और वो साइलेंसर के बिना जो बाइक उसकी गुजरी मोहल्ले से, उससे बहुत शोर हुआ, और फिर किसी ने उससे झगड़ा किया, और झगड़े में फिर वो उस इंसान ने मोटर बाइक वाले पे सेडिशन का केस लगा दिया, और वो लग भी गया. तो मैं मानता हूं कि जो बाइक बिना साइलेंसर के चलाते हैं उन पे कुछ ना कुछ तो कार्रवाई होनी चाहिए, लेकिन सेडिशन नहीं होना चाहिए, वो भी एक और बात है. लेकिन अगर उस चीज पे सेडिशन लग सकता है, तो फिर हमारे जोक पे तो लग ही सकता है. तो फिर वो आई डोंट नो सलमान खान की फिल्म का डायलॉग होगा या किसी फिल्म का है ऐसा कि इतना मत डराओ कि डर खत्म हो जाए टाइप्स ना, वैसा है कुछ। तो ये इतना ज्यादा डरा दिया है कि वो फिर डर कम तो हो ही गया है, खत्म तो कभी नहीं होता, क्योंकि डर हमारी पर्सनालिटी का हिस्सा, मेरा तो बहुत ज्यादा है। आई एम अ बिट ऑफ अ पैरानॉइड पर्सन एंड स्टिल आई डू कॉमेडी, सो देयर इज सम काइंड ऑफ आई डोंट नो यहाँ पे कुछ है प्रॉब्लम। पर generally I'm not talking about me, but yeah, generally about the comedy, the comedy scene, the environment in comedy community. I think everyone is scared. Everyone knows a few lawyers, even if they are not using them till now, but everyone, हम जिस भी नए शहर में जाते हैं परफॉर्म करने, हम सबसे पहले जाने के पहले ही लॉयर से बात करके रखते हैं कि भाई हम आ रहे हैं आपके शहर, और आप मतलब जरूरत ना पड़े तो बहुत अच्छा, लेकिन जरूरत पड़ेगी तो आप प्लीज फास्ट डायल पे रहें। रात को 11 बजे 12 बजे कभी भी कुछ भी हो सकता है।
ये आप
तो ये
सीरियसली कह रहे हैं कि दिस इज यू सीरियसली डू दिस
हाफ सीरियस इन अ वे, या बट ये सच है, और ये सिर्फ मेरा सच नहीं है, ये पूरी कॉमेडी कम्युनिटी का सच है कि इस समय हर चीज में आप डरते हैं। पर जैसा कि जहां से बात शुरू हुई, देर इज if there was a logic to these things, there is still a way to kind of dodge the bullet. But if there is no logic, you don't even know if there is a bullet coming, or they'll or the ground under you will just part and you'll fall down, or something will happen, or the sky will fall. I don't know what will happen. So the thing is, it is becoming increasingly difficult, and I think that is the game plan here, to make it so unpredictable, so that the artist, at least, or anyone, any dissident voice, becomes confused. Like आपने 6-8 महीने यहाँ पे जो आपके पत्रकार हैं और लॉयर्स हैं, वो 6-8 महीने में क्या क्या कर सकते थे जिंदगी में? वो ये एक लिस्ट बना रहे हैं बैठ के कि कहाँ पे किस वजह से सेडिशन, दे आर वेस्टिंग आवर टाइम एंड दे आर कीपिंग अस एंगेज्ड विद सो मेनी रैंडम थिंग्स। साइलेंसर की वजह से, कहीं पे क्रिकेट मैच की वजह, क्रिकेट मैच में झगड़ा हुआ उसमें फिर सेडिशन लगा दिया, कहीं पे कोई I think there was another case about a love marriage, and then the girl went back to her family, and then the family kept her, and then the husband went back to get the wife, and there was some fight there, and then they put a sedition. लव मैरिज में भी सेडिशन लगाया जा सकता है, मतलब कहाँ पे वो हर तरफ से लड़ रहे हैं। आप लव जिहाद वाले केस में नहीं फंसाएंगे तो सेडिशन में फंसा देंगे, वो किसी ना किसी तरह से आपको फंसा रहे हैं। सो ऑल ऑफ दिस इज very confusing, very exhausting, and I think the impact is quite visible in the comedy we see around us. Like it is very different from the comedy which was happening, let's say 5 years ago even, or 4 years ago. And I don't know what is the way out, because they are I mean, the way these whatever these tools are being used, there is, I mean, as an artist, I don't have any answers to how to go about it. It's mostly instinctive or intuitive, in a way ki, okay, I know ki this is probably a red line, probably a line I might, if I cross, I'll be like, right now when we are doing this, I know this is almost a red line, कि ये शो, ये प्रोग्राम जो है जिस पे हम बात कर रहे हैं और ये पूरी दुनिया में जा रहा है, I can already imagine a scenario where this clip where I'm talking about sedition is taken out of context and put somewhere and claimed to be seditious. Just talking about sedition, talking about a case of sedition could be seditious, because anything could be seditious ultimately. तो वो एक
reality is more absurd than any joke in a sense.
या वो एक बहुत पुराना सा चुटकुला था, बहुत ही बचकाना सा है, कि वो एक डॉक्टर के पास एक बंदा आता है और वो बात करना चाहता है डॉक्टर से, और डॉक्टर बोलता है कि अच्छा कपड़े उतारो और वहां लेट जाओ। वो जबरदस्ती उसको 2 लोग पकड़ के लिटा देते हैं, उसके मुंह में थर्मोमीटर डाल देते हैं, और फिर थोड़ी देर 50 तरह के चेकअप होते हैं। डॉक्टर बोलता है सब तो ठीक है, तुम क्या करने आए हो? बोला मैं तो पोस्टमैन हूँ, मैं चिट्ठी देने आया था। सो यहाँ पे हर इंसान, मतलब वो जो एक डॉक्टर की मोडस ऑपरेंडी है कि पहला काम ये है, उसको लिटा दो, कपड़े उतारो और मुंह में थर्मोमीटर डाल दो, दैट इज व्हाट दे आर डूइंग। किसी को भी सेडिशन लगा दो, बाद में पूछो कि किया क्या है उसने, वो किस काम से यहाँ आया था, है ना। वो डॉक्टर के, कम से कम डॉक्टर के चेंबर में तो वो आया था पोस्टमैन, जिसपे उसने वो, जिसके मुंह में थर्मोमीटर डाल दिया। यहाँ तो सड़क से पकड़ रहे हैं ये लोग, जो सड़क से लोग जा रहे हैं गाड़ियों में, उनको पकड़ के अंदर ले जाया जा रहा है, उनके कपड़े उतार के उनके मुंह में थर्मोमीटर डाला जा रहा है। और मजे की बात यह है कि जो ये कर रहे हैं वो डॉक्टर भी नहीं है, वो गुंडे हैं एक तरह से, और वो ये काम कर रहे हैं। तो ये, दिस इज द काइंड ऑफ द एनालॉजी आई हैव अबाउट व्हाट इज हैपनिंग राइट नाउ। तो
yeah. So, Rebecca, it's a very good time to bring you in about this whole question of the absurdity of the way this law plays out. You have lived the findings of these data, the travesties and the absurdities that Varun talked about now, the travesties of the rule of law, the trauma caused to the accused and the families. Tell us how the high or low points, some of the high and low points of how sedition cases unfold in court.
Thanks, Samar. Actually, sedition cases don't really end. They begin, so there's a point at which they all start, and there's a lot of noise, lot of arrests, all of them get bail, and then they just die away because we don't really see it traveling the journey of a trial in court. I have yet to see a case which has ended. This law is largely used to frighten people, to register FIRs, to enforce an arrest, to make sure that there is some noise after the arrest. But then the charge sheet is filed and then nothing really happens. It just goes on and on and on forever. And I think that's there even in the data that you have collected. People spend a large amount of their time and money to get bail. But once that is done, and I noticed that in your report, there's this fascinating observation where you say that nearly every person accused of sedition that we interviewed said that they had sold land, jewelry, livestock, and taken on debt to pay legal fees and bail bonds. It is actually very tragic. These are the kind of people that you're invoking 124A against. So I haven't really seen that many cases that have ended. I've seen a lot of cases that have begun and are still in limbo. So that's one observation. The other thing that I can say is that, you see, if you were to look at some of the cases that have played out in the last couple of years, on January 26, 2021, when the farmers came into Delhi, there was this incident that took place in the heart of Delhi at one of the busiest intersections, ITO, where a man driving a tractor, it overturned and the sole occupant of the tractor died. Everybody tweeted about it. And a little while later, some journalists said that there was some chatter from eyewitness accounts that he had been shot. That was put on Twitter. And thereafter, there was a clarification given by the Delhi police, which was also largely put on Twitter. Notwithstanding that, by the end of the day, at least by midnight, there were cases that were registered in various parts of the country. In the next 2 or 3 days, it multiplied, and the same journalists were targeted by having cases registered across India, compelling us to go to the Supreme Court. Of course, the matter was stayed, and the matter is still sub judice. The point is, what was said? The only thing that was said was, here's a tractor which is overturned, somebody has died, and some eyewitnesses are saying that he was shot. Thereafter, clarification was posted. But 124A was invoked, sedition was invoked, along with a basket of other provisions which are routinely invoked, which is 153A and 505. And these all of these provisions go together, hand in hand.
Sorry, can you just tell everyone what's 135A, 153A, and 505, so that everyone knows?
Yeah, so 124A, of course, is sedition. 153A is promoting enmity between different groups on grounds of religion, race, place of birth, residence, etc. And 505 are statements conducing to public mischief. Statements made, statement made or circulated with the intent to cause mischief. So these provisions go hand in hand. And I would also like to make the point that there is an overlap between 124A and UAPA. So if you were to see Section 2O of UAPA, which defines, which penalizes any action which causes or is intended to cause disaffection against India, there's again this overlap. So 124A sedition is also used along with UAPA. Of course, under 124A, there are certain explanations which prevent comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection. That is not sedition. So that's part of the section. But those filters are not there in UAPA. And so UAPA gets attracted, 124A gets attracted, 153A gets attracted, either individually or collectively, but they all go hand in hand. And there is not that much difference when the police officer decides there's no real basis for him to invoke one provision and not the other. He decides to invoke all of them together. So coming back to your question, how does it play out in courts? Well, the noise is when it is registered. The noise is when the bail hearings take place, and immediately after the bail hearing. If you ask whether any of these cases will withstand judicial scrutiny, largely they won't. And mostly they won't. They end in acquittals, if at all they complete the journey. And that's the way it plays out. Just one more example. In a case that took place in 2016 pertaining to some student leaders of JNU, it was all based on sloganeering, and including slogans that some of these student leaders had never ever they'd never ever spoken about those words which were purportedly used by them. Now, the Delhi police took a long time to file the charge sheet in that case, but in the interregnum, the university had taken on disciplinary proceedings against these student leaders. Those disciplinary proceedings came to a conclusion with the university penalizing these student leaders. A writ petition was filed in the Delhi High Court. These were civil proceedings. And the Delhi High Court throughout the disciplinary proceedings, saying that this cannot withstand scrutiny. Same evidence, disciplinary proceedings by the university, criminal proceedings by the police. The criminal proceedings continue. The disciplinary proceedings was thrown out. And the Delhi High Court said there was no basis for the university to have fined those students after examining the same slogans and the same material. So where the threshold of proof or the standard of proof is higher, which is criminal proceedings, you have the criminal case still going on. But the civil case, where the standard of proof is much lower, you have the High Court saying no case is made out.
I'm just going to keep this as open as possible. So if anyone in the audience has questions, please keep them coming, because I'm seeing a lot of them flowing in. There's someone who's already saying that I came here for Varun, but it's getting really interesting. And there are others who have some other questions about bail in seditious cases. So we'll come back to that. I just want to ask before that, I want to ask Aakar, I'd like you to give us a bit of a global perspective. Why is India, among major democracies, unique in retaining sedition? And why do you think no government, whether run by the Congress or the BJP, will let go of this?
So we are not unique. We are part of the South Asian Commonwealth that all has it. So Bangladesh has it, Pakistan has it, we have it. The rest of the Commonwealth, including Australia, New Zealand, have read it down. The UK has got rid of it. The US doesn't have it and has not had it for a couple of 100 years. The law, so this is an unusual law. So we know what murder means, we know what theft means, we don't know what disaffection means. So basically, it was written in during the English Civil War, when they were killing their kings, and the man who took charge, Charles II, who got Bombay as dowry, he is the man under whom this law came to be. So disaffection against the monarch is what the law said, and then it became government when we all became independent. So most civilized nations don't have this law anymore. We have it, as does the rest of our sisters in Bangladesh and Pakistan also have it. But most of the civilized world, including common law countries, do not have it. Which is interesting also because of what Lubhyathi said, that we have a very clear judgment on what the operation of the law should be in Kedarnath, which is more than 50 years old. But the beauty of India is that the lower judiciary and the police can overrule the Supreme Court. So you've got very clear guidelines which nobody follows. So the guidelines don't mean anything. And the law is to be operational only when there is a clear call to violence. That if I clearly call for violence against the state, it is only then that I may be accused and charged of being seditious. That is not followed. So when Amnesty was accused of sedition in 2016, we are one of the few cases that actually saw resolution. We were taking around these mothers of Kashmiri children who had been killed by the armed forces and had not received justice and had not had their cases filed and had not seen a court. So we were taking their stories around the country. At the first possible instance where we did this, which was in Bangalore, the police told us to shut the program before we could conclude. And there was a Kashmiri rapper who most of the youngsters had come to see, and he only got a couple of minutes in before the police shut the thing down. And some of the students used the word Azadi as a slogan, which provoked the ABVP into filing a sedition case against us. They were very brave, the ABVP, but didn't show up in court a single time. What happened was this, that I spoke to the police at some depth. They spent more than a crore rupees and 2 years investigating this, sending all the videotapes to the forensics lab. There was an 88-page report from that lab. And in the end, what happened was what is called a B report, that no crime was made out. So after 2 years of damage to us as an institution, the maligning of the institution on television, as is normal in this country at this point in time, the waste of a lot of time from the police and the authorities and public money, it came to naught. So that is where the thing is. This is a law which very few understand, including the police. It is deployed and applied in places where it ought not to be, in defiance of very clear Supreme Court guidelines, and will continue to be. I think that the reason why India, Pakistan, and Bangladesh will continue to have this law is that disaffection against the state, whatever it might mean, I don't know what it means, is something that we hold quite dearly, and the state really wants to hold on to. So the state doesn't want the citizenry, which is for the most part a praja, and the state is Raja. The state doesn't want the citizenry to express any form of dissent, and this law is the perfect weapon that can be used because it's vague. Nobody, including the lower judiciary and the police, actually understand the law. I can tell you for a fact that most judges in India will not be able to give you a very clean explanation of what disaffection means. A law that the state that wrote it, UK, killed it. The fact that they didn't want disaffection against the new king, Charles II, who did not have legitimacy, was not only read down, it was taken off the books in the UK and the US 200 years ago, remains on the books here, and I think will remain for some time, and that some time I think will be about 15 or 20 years.
It's interesting all that you said, because I think one of our findings was that of all the cases that we examined, Lubhyathi will correct me if I'm wrong, the conviction rate was about 0.1% in these sedition cases, which actually tells you what exactly is going on. And as one of our viewers is saying,
just to add to what Rebecca John said, it's absolutely right that the focus of the state and of the media is on the initial period. It's the noise during the time that a statement is thought to have been made. Somebody doesn't know whether orange or green is on top of the flag or at the bottom of the flag, and a case is filed. There are stories in the media. Those 4, 5, 6 days and maybe a week and a half is where the focus is. After that, it dies. The state has no interest in pursuing this. It only adds to the backlog of what the police does. Total waste of everybody's time, and I'm not surprised to hear the data that you have.
When someone's Renuka Mani in the audience is asking, when is bail given for seditious cases? Is there a pattern for that? And will people like Umar Khalid and others be given bail or not because they're under UAPA? I'll get Rebecca to quickly address that before we move on.
I wish I had the answer to that question. I don't know when bail will be given. It's been 6 months since we've been arguing. Of course, the charge against them in that case is not just 124A. It is other offenses of UAPA. So UAPA has a different regime altogether, including a different bail regime. And so therefore, getting bail under UAPA is extremely difficult. So that's all I can say at the moment. Can I just add on to what everyone has said about Kedarnath Singh? Because I think you need to know what the Supreme Court, the Constitution Bench judgment of the Supreme Court in Kedarnath Singh has said. It has said very clearly that it is only when the words written or spoken which have the pernicious tendency or intention of creating public disorder or disturbance of law and order that the law steps in to prevent such activities in the interest of public order. So unless the words written or spoken have a pernicious tendency or intention of creating public disorder or disturbance of law or incitement to violence, Section 124A, according to the Supreme Court, should not be invoked.
Yeah. So that is very clear. There's no. It's very clear what the Supreme Court has said about this. There's one of our audience, Jaydeep Raja, is saying even Kafka could not have thought this up. Life imitates art, which is more interesting than the other way around, which of course is extremely interesting and macabre at the same time. But Varun, let me ask you, in a situation like this, I think between Lubhyathi, Rebecca, and Aakar, they pretty much laid out the situation that we are under this law. What are let me ask you a question from the other end of the spectrum, from the people who are observing, people like you and me, people in the audience, so to say, and literally people in the audience. For example, your audience, if someone is listening to you, are you ever afraid of your audience in a situation like this? Because we were just talking earlier about a situation where Varun had a show organized by the German embassy with a business show. So there were businessmen, German and Indian, and he started off. It was a half an hour show, but basically he was shut down in 9 minutes because he started making jokes about whatever, the traffic, cows on the street, whatever. And of course, I think the Indian businessman, he'll correct me if I'm wrong, got a little irritated at that, and the Germans thought this was funny and they laughed out loud. He was being booed, I think, from the audience. I think it ended at that. But of course, in this day and age, it can go into anything. It can go into sedition, etc. So what does it say about the people at the other end who are listening in, all the Indian audience, so to say, whether on social media or whether on live shows, etc., that they are perfectly willing to go along with this whole regime of sedition, so to say?
Yeah, I think we are inherently a control society, as in we love being controlled. We love being told what to do. We love being told how to think, what to think. And that kind of वो बचपन से हमको जो conformity सिखाई गई है ना, वो बहुत ज़्यादा शुरू में लगता है बहुत सभ्यता वाली चीज़ है, बहुत सत्कार हम लोग करते हैं, बड़ों के पैर छुओ, टीचर की इज्जत करो, टीचर से क्रॉस क्वेश्चन मत करो, कोई भी चीज़, मतलब स्कूल से लेकर घर से लेकर मोहल्ले से लेकर कॉलेज में जाकर हर जगह मतलब एक प्रोफेसर थे हमारे जो सिर्फ इस बात पे डांटते थे कि आप लोग लेदर शूज विद सॉक्स पहनकर नहीं आए हैं क्लास में. इट वाज इन एन इंजीनियरिंग क्लास एंड इट वाज अ क्लास. इट वाज नॉट इवन अ लैब वेयर ओके आई कैन अंडरस्टैंड द सेफ्टी मेजर्स ऑफ वेयरिंग शूज एंड प्रॉपर कि कोई हैवी इक्विपमेंट आपके ऊपर ना गिर जाए. क्लास में तो उनके पास कोई भी हैवी आइडिया नहीं होता था कि वो पैर पे गिर जाए और हमारा पैर टूट जाए. वो चाहते थे लेकिन कि आप एक अच्छे और वो सब फॉलो भी करते थे. इट वाज अ मैटर ऑफ फॉर सम किड्स इट वाज अ मैटर ऑफ pride that they followed this random diktat for one professor who wanted to enforce this very stupid law or rule. और हम लोगों को बचपन से जो सिखाया गया है वो उसी का एक हिस्सा ये है जहाँ पे हम हमेशा वी हैव दिस टेंडेंसी ऑफ ऑलवेज trusting the authority unless it's not talking to us, right? So अथॉरिटी ने जो बोला है, अथॉरिटी ने बोल दिया. वहां पे उन्होंने नारे लगाए थे, कुछ बहुत ही गंदे नारे थे और उनको जेल में डाल देना चाहिए. हाँ हाँ बिल्कुल बिल्कुल डाल देना. वो पूरा देश का हर जगह वो रहता है, हर जगह. अभी कोई भी कुछ भी, जैसे वो जो एग्जाम्पल्स हैं उसमें अजीब अजीब चीजें हैं. एग्जाम्पल्स में एक टी शर्ट पहना हुआ था किसी ने और वो फोटो डाला था जो शायद आपने भी बात की, आइदर इट वाज अ मुहर्रम प्रोसेशन और समथिंग, बट a bunch of kids posted a photo with some t-shirts and somebody claimed they are wearing t-shirts of Pakistan flag, and that became seditious. Now sedition law, as was just described by Rebecca and Aakar, it needs to incite violence against the state. Now if a state is kind of getting threatened by a t-shirt, even if it was Pakistan t-shirt, I don't know the truth and I don't think the cops will also ever find out what was the truth, but yeah, the case was filed and all. So क्या स्टेट इतना कमजोर घबराया हुआ है कि एक टी शर्ट से वो टी शर्ट पहनने को वायलेंस मान लिया जाए, वो भी अगेंस्ट द स्टेट या कॉन्स्पिरेसी अगेंस्ट द स्टेट? क्योंकि ये जो शब्द जो है सेडिशन, जो हमने पढ़ा था बचपन में, राजद्रोह है. शायद इसका ओरिजिनल जो मीनिंग था इट वाज राजद्रोह, जिसको अब हम देशद्रोह बोल देते हैं. लेकिन राजद्रोह तो, राज तो ब्रिटिश राज था, राज भी नहीं रहा है. राज को गए हुए 72 साल हो गए और 75 साल हो गए, 75 होने वाले, सॉरी, और 152 साल इस लॉ को बने हुए हो गए. शायद 1870 में बना है. तो राज को गए हुए जितना टाइम हो गया उससे डबल टाइम पहले ये लॉ बना था. और इतनी पुरानी चीज, वो ठीक है, इन लोगों को पुरानी चीजों से बहुत प्यार है, वो हमको पता है, और पुरानी चीजों से ही ज्यादा प्यार है, वो भी हमको पता है. पर ये देशद्रोह या राजद्रोह कैसे हुआ एक टी शर्ट पहनना, वो मुझे बिल्कुल नहीं समझ में आता है. बट मुझे ये भी पता है, जो हम सबको पता है, कि देयर इज अ मेजर public support to this idea of sedition, right? That's why the law is still there. And it comes from simply the trust in power or trust in authority. Power, ठीक है, वो authority is the fact and power is the corollary in a way of that fact. पर हम मान के चलते हैं, कुछ भी बोल दे आपको सरकार या मीडिया. आज की तारीख में तो मीडिया ही असल में सरकार चला रहा है, मुझे ऐसा लगता है. इनफैक्ट बहुत सारे स्टूपिड डिसीजन जो होते हैं, मुझे लगता है कि वो मीडिया में, क्योंकि उस पर बात होती है तो ये तुरंत ये सोचते हैं हाँ हवा इधर चल रही है. तो ट्विटर पोल्स या वट एवर द न्यूज गोदी मीडिया, व्हाट वी कॉल देम, उन सब से ये चीजें बन रही हैं. तो वो नाउ इट हैज बिकम अ काइंड ऑफ सर्कल जहाँ पे समझ नहीं आ रहा है कि मीडिया पहले वो चीजें उनकी हवा बनाता है, उसके बाद वो होता है, या पहले वो होता है उसके बाद मीडिया उसको सपोर्ट करने के लिए पूरी की पूरी पूरा एक सिस्टम देता है आपको. पर सारी बातों की एक बात ये कि हम लोग मेंटली शायद 6 साल के हैं और हमको हर चीज बताई जा रही है और हम उसी तरह से कर रहे हैं, और वहां पे हम अटक गए हैं. 152 तो 3 नंबर हैं यहाँ पे, 75, 152 और 6. इन 3 नंबर्स के बीच में हम फंस चुके हैं और अब इससे निकलना बहुत ही मुश्किल लग रहा है मुझे. जो रेबेका ने भी बोला कि कोई उम्मीद नहीं है, हम लोग यही कर सकते हैं कि इस तरह के कॉन्फ्रेंस करते रहें ऑनलाइन जब तक कि हम में से एक एक करके सब जेल ना जा रहे हो, और फिर यहाँ पे सिर्फ एक खाली कमरे रहेंगे, पीछे जो फोटोज लगी हैं, इधर अमरीश पुरी लगे हुए मेरे पीछे, आपके पीछे कुछ सुंदर सा एक फोटोग्राफ लगा है.
हाँ, that's
हाँ.
Bombay in 1870.
Oh wow, okay, exactly the year probably.
Coincidentally, yes.
That's Churchgate or South
No,
Bombay or something?
that's yeah, Bombay University.
Oh, okay.
Yeah,
Uh-huh.
that's Bombay University before Marine Drive came up. So
ठीक
now
है.
we can go on and on. Unfortunately, we are running out of time. There's some terrific questions. We have a terrific panel. Which we will go on, but we'll run just a little over. I just want to very quickly, and I had questions of Lubhyathi and all the other two, but I think now we have a little time just for the other two. There's somebody who's asking, and I think this is a valid question. How come there are 2-3 people who have asked this actually, Rebecca? How is there no judicial process internally to get rid of a law like this? Basically, does the judiciary not care? How has it gone on year after year after year? So that's for you. After that, Aakar, somebody is saying that you're being very optimistic if you think that the law will be removed in 15 to 20 years. It will never be removed. And that, I think, feeds into what Varun was saying, that many of us actually want this law. So first, Rebecca, and then Aakar.
Yeah, quickly, just one thing I want to say. I think the only thing that can save us from this law now is climate crisis.
Sorry? Climate?
Climate crisis. The world will end before the law ends, I think.
On an optimistic note, Rebecca, please.
Yes. So actually, the Supreme Court has taken up a bunch of petitions challenging the constitutional validity of sedition, and it has to be listed for hearing. I think the Kedarnath guidelines have outlived their use, and I think there's need to relook 124A. I hope the Supreme Court will do that. Last year, these petitions were taken up and notice has been issued, and I think it's time that its constitutional validity is tested. And I hope the apex court does that. Otherwise, it is for Parliament to decide whether this remains on the statute book or not, and Parliament is clearly not interested in deleting this provision. It doesn't matter who is in power. I think all the governments in power and all the governments in the various states in India have used this very creatively. So I don't think it's in the interest of the government or the state to ensure, or the Parliament to ensure that the law is deleted from our statute books. Ultimately, it will have to be the Supreme Court which will decide once again whether it is constitutionally valid or not. Kedarnath Singh said it was valid, but there were these tests which were laid out, and only if the action or the words resulted in violence or had a propensity to violence could this provision be invoked. I agree with Aakar. The way the section has been drafted, it is impossible for a thanedar to understand the meaning of this section, and therefore it's used just as a provision that can be misused and to fix people. Otherwise, I don't think any police officer will understand what 124A is all about and what is the meaning of that section. I hope the Supreme Court ultimately decides that it is unconstitutional.
I have to very quickly put in a plug for us. 5 of those petitions actually quote data from this database.
Yes, that's right. That's right. That's absolutely right. That's absolutely right. I should have said that.
Also, there's a quick, very, very quick follow-up question for you. I hate to do this, but the questions are just flowing in. Rebecca, someone's asking, and this is a very simple question: why do the courts never reprimand the police for delayed charge sheet filing?
Maybe I should just add to that question, in case one of our viewers has something like this filed against them. Rebecca, John, what ought they to do? I think it might be helpful for us to know what the first line of defense should be.
So if the act has not resulted in violence, it's just a Facebook post or it's a tweet, there are a whole lot of these petitions being filed again in the Supreme Court because of what happened in Tripura and the Tripura police going after people who had simply tweeted about what was happening on the ground. I think it is important for them to file writ petitions either in their respective high courts, or if there are far too many of them, to come in a 32 petition in the Supreme Court. The Supreme Court, by and large, intervenes and stays arrest or ensures that no coercive action is taken. Of course, if you're picked up before you are able to file a petition, then the only option is to apply for bail. And as it happened in the case of the JNU students, that took some 3 or 4 weeks, which was still reasonably fast, I would say, because there are many, many people languishing in jail for months and years to come, years on end, for cases under 124A. So I would say that if you have the time, a petition for quashing is really what you should do, because most of these cases are untenable, unsustainable on account of the Constitution bench judgment of the Supreme Court in Kedarnath Singh.
Thank you, Rebecca. That was terrific. Last word to you, Aakar, picking up directly from what Varun said, that we seem to want this law. Do we not?
Unfortunately for us, I think that the basis of our constitution is not the Manusmriti. Had it been that, we would have lived with it for slightly longer. The problem is that if you live in a world where you have common law, you have to live by a precedent, and you look at what the rest of the world does. I think based on that, I give this law between 7 and 10 years. I could be optimistic. I think it'll probably die before that. Rebecca John mentioned the Supreme Court taking this up in July. It was done by the Chief Justice himself. He hasn't heard it since. My guess is that either a change in government or some external pressure will put an end to laws like the UAPA and sedition in the medium term, by which I mean 7 to 10 years. I don't think that a country that has a liberal constitution, as we do, can live on with laws such as sedition and UAPA for too long. Modernity has a way of squashing stupidity, and I think that for us, unfortunately for all of us, our stupidity will be only given about 7 to 10 years more to live.
All right, thank you. And I'm really sorry, but just on that, I have to very quickly bring Varun in again on the whole question of stupidity. How do we live until all this happens, Varun? How do we live with the stupidity?
Okay, I think the only way to deal with stupidity is stupidity. Like, be unpredictable, basically. I would say be unpredictable. Find novel ways of saying what you want to say. Find new media. Find, like what Aakar is doing right now on Twitter. Find narratives. Don't. So what I have been feeling for a few years now, last 3-4 years. I think the op-ed is dead. Okay, so nobody is going to read your opinion. People can still relate to stories, still relate to comedy, relate to anything which has a narrative, which is an instinctive response of human brain. Immediately you get hooked to something which has a story you want, even if that story doesn't align with your worldview. You will listen to or respond to a story. So I think we need to find novel ways of keeping our our conscience and our constitution alive with everything everything we believe in has to come out as a story. Even if in the worst case scenario, the story will still be there. We may not be there, and the principles may not be there, but the stories that talk about those principles will be there. So yeah.
Fantastic. So thank you very much, everyone, for this optimistic ending.
Just to say that it's we, the people, who've adopted our constitution. So I think at the end of the day, we must uphold that principle.
Absolutely. Thank you, Rebecca. Thank you, Aakar. Thank you, Varun. And thank you, Lubhyathi, for making all this happen in the first place.
Thank you.
And let us hope we start scripting our own new narratives.